In America, you might have to go through arbitration, but in Canada, you can still sue Uber to your heart's content. Hey everyone, this is Kevin the Apptrepreneur, and we all know that in California, you can no longer sue Uber in a class action lawsuit. It has to be done through arbitration. I think that sucks. I think people should be allowed to sue in class action lawsuits if they please, even if I am dubious of whether or not they actually do anything. But I had to give the Uber drivers credit. They really stuck it to them. They just flooded their offices with arbitration demands, and when Uber couldn't keep up, they sued them for not following the law. It was quite brilliant, really. Ahowever, Canada, particularly Ontario, basically said, no, arbitration is not a thing. You can still sue them. So according to Aginst, the Court of Appeal for Ontario declared on Wednesday that Uber's arbitration clause for its drivers is invalid, both because it violates the Arbitration Act and because the arbitration clause is unconscionable. The lawsuit was filed by an Uber driver who was seeking a class action lawsuit designation that seeks to declare that Uber drivers are employees of Uber. The arbitration clause that Uber drivers sign requires that disputes, conflicts, and controversies get resolved through arbitration. It also requires that the Uber driver pay the administrative filing related costs of the arbitration up front. I don't know if that's a thing in California, but that sucks for Canada, which is estimated to cost around $14,500. You know, I did videos and people complained, rightfully so, about Lyft's $5,000 deductible fee, where if you got into an accident while on Lyft, Lyft would pay the damages minus $5,000 that you would have to provide. How many drivers actually have $5,000 in their savings? Not a lot, I'm sorry to say. I'm finally almost there, but I was living paycheck to paycheck for a long time before I took a very valuable money class, and oh boy, that changed my life quite a bit. So that, I could not imagine having almost $15,000 set aside to go to arbitration. Boy, no wonder, I would just quit at that point. And then this might be one of the reasons why the courts have ruled against the arbitration. Because the clause was determined to violate the Arbitration Act because it contracts out an employment standard of the Employment Standards Act. The court determined that the arbitration clause, quote, eliminates the right of the appellant or any other driver to make a complaint to the Ministry of Labor regarding the actions of Uber and their possible violation of the requirements of the ESA. In doing so, it deprives the appellant on the right to have an employment standards officer investigate his complaint. The clause was found to be unconscionable because the requirement to pay upfront costs are a, this is great, quote, substantially improvident or unfair bargain. Oh my gosh. I don't even know 100% what that means, but that is beautifully written. Substantially improvident or unfair bargain. I love how they use the term unfair bargain. Like, yeah, if you win a lot of money through arbitration, yeah, $50,000 is probably a bargain, but it's an unfair one because it's one that most people can't afford up front anyway. That was great. The court also found that there was, quote, no reasonable prospect of being able to negotiate any of the terms. So, no, there's not. And significantly inequality in bargaining power. What's that at Uber? It was also determined that Uber knowingly and intentionally chose this arbitration clause in order to favor itself and thus take advantage of its drivers. Do you think? In the U.S., the Court of Appeals for the Ninth Circuit found in September that Uber can require drivers to go through arbitration regarding the classification of its drivers. Yeah, but we're not exactly charging 15 grand up front to do it. In May, Uber declared that it would no longer require sexual assault and sexual harassment claims to be resolved through arbitration. Was I aware of that? I don't know if I was aware of that. I mean, granted, I report on so many Uber stories, it's easy to lose track of them. But, wow. That is, that's That's actually a good thing if that's true, because yeah, those things should not go through arbitration. I don't care how much you like Uber. That's nonsense. So anyway, there you go. So what does this basically mean? Well, it means that you're going to see some class action lawsuits in Ontario. I'm sorry. It's that simple. Because the arbitration was probably getting in the way of many drivers voicing their complaints to Uber through the legal system. And Uber loves arbitration because they always win in it. And you know what? In a situation where you could win your cases and make the employee pay for it for bringing it to your attention, oh my gosh, what a great system. You would think that if that was what you had to do, at least you could pick your own legal representation, not Uber's. But hey, the Ontario appeals courts, they have struck that down. So no doing that. Not even close. I really thought I'd have a little bit more to say about this, but no, it really is that straightforward. It is. So I guess we're just going to leave it there. No need. So 2 short videos today. You can come back tomorrow. The videos will be a heck of a lot longer, I believe. Well, tomorrow's Saturday, so yeah, I'm going to upload a couple videos still. There's one about Microsoft suing Barnes & Noble that might be fun to talk about. So anyway, what do you folks think? Any of you live in Ontario, Canada? Is this going to be to your advantage? Do you plan to join any class action lawsuits? I would love to know. So, comment below. Like, favorite, share, subscribe. If you enjoy my videos, consider becoming a Patreon member. It's totally optional, but even as little as $1 a month goes a long way to helping the channel run smoothly. Plus, you will get access to my exclusive blog. That actually, I believe, is going up Saturday. So, yeah, there's going to be some stuff coming from the Apptrepreneur this weekend. It's going to be fun. So, anyway, and as always, flame responsibly. Have a good one.